We are Nigeria Info.
Information is a two-way thing. Nigeria Info, it's your turn. Let's talk.
And now, Hard Facts. Hard Facts with Dayo.
Welcome back, and thanks for staying tuned to Hard Facts 90.3 Nigeria Info and her input Harcourt. I'm Dayo. 9 minutes gone past 5 p.m. The conversation continues. And you can't ever, you can't afford to get tired of the conversation continuing. The moment you get tired of it, you're gone. Literally. Conversation continues. And also very important, the conversation is not just for us to excite ourselves every now and then, under the guise that we're, after all, talking about it. It's a view to effecting a mind shift, a perspective change to the situation, and to come to a realization that there is a responsibility of everyone, and that is something that you can do to change the narrative. And I do hope we get there. Now, moving on right now, the next matter of discourse, story here cut to the Premium Times. You can find similar versions in other dailies. Conflicting court orders, CJN summons 6 chief judges, NBA laments. The judicial officers summoned by the CJN are chief judges of states in the South, Northwest and Southeast regions. And the CJN, Mohammed, has summoned the chief judges of 6 states over the recent wave of conflicting orders issued from their courts. Now, Mr. Mohammed is the chairman of the National Judicial Council, a statutory body concerned with appointment and disciplining of judges, issued the summons to the affected chief judges in Abuja on Monday. The states, by the way, concerned are Rivers, Kebbi, Cross River, Anambra, Jigawa, and Imo states. The questionable ex-parte orders issued in various political cases emanated from the judges of the 6 states in the last 2 months. Spokesperson for the CJN, Ahuraka Isa, confirmed the summons issued by Mr. Mohammed to the chief judges. The affected heads of court are to appear before the CJN as a prelude to the broader probe by the NJC to explain what warranted issuance of conflicting orders by courts of coordinate jurisdiction in their domains. Excerpts from the summons were shared with our reporter, when we'll get to that later on. But let's get into the matter right now. Is the judiciary still the hope of the common man? Are court orders now for sale in Nigeria? Well, joining me for this conversation, he's a lawyer. He's also with the Committee for the Defense of Human Rights, Henry Ekine. Henry, good evening to you. Welcome to Hard Facts.
Thank you very much, Dayo, and good evening to all our esteemed listeners. I appreciate being here.
Great. Let's talk about the issue itself before we go to the CJN summons. What exactly is the problem here? Let's talk about frivolous orders of conflicting orders being issued by courts left, right, center, courts of coordinate jurisdiction, overturning each other on different issues, especially in political matters lately. Can you explain what exactly the concern, the problem is with that picture?
Well, it is a concern, and then it's worrisome, and I think that's basically because it puts a question to the integrity of the judiciary. And then, of course, to coordination in the handling of matters before the courts. And again, it threatens also the independence of the judiciary. It again affects the perception of the people on how they regard the orders and judgments and decisions of courts. Now, all of this put together, to be clear, so we could easily understand, is when you begin to have orders made by courts or judgments made by court that are expected to be obeyed by all persons, whether directly affected as being parties or not, you would imagine where if these orders are coming in such, dispersed manner, that you would wonder whether the courts themselves are even listening to each other or hearing each other or following the trend of the happenings on the subjects that are before them. That's not to say that the courts are under any obligation to listen to the others, but for coordination and then for some sense of harmonization of the things that are going on in the judiciary. It's important. And that would also raise a question as to whether we even have that kind of arrangement or that kind of facility made available. Even now that the CJ, and we haven't really gotten to that, is calling them, are there opportunities for judges as far away from Kebbi and Port Harcourt to be able to really know that something similar before you has come up somewhere else and what the order has been? But these are questions that we need to answer even as we're going on.
Now, in this particular case, and I believe you're referring to the matter of the PDP's, who is the substantive chairman of the PDP on the national level. Is it possible that? Okay, I'll come to that question in a moment. This question should precede that. I'd like you to explain it technically, in technical terms, what exactly the problem is.
Now, the problem is this. Let me explain this problem by actually putting in context what ex parte orders are, so that we can imagine even the effect it could have, and then why this idea of conflicting. Conflicting orders or judgments will be such that will affect the orders, the earlier orders or judgments made in similar situation on the same subject matter, for most importantly and very worrisome, same subject matter, because the parties may differ really, but the subject matter that has come before a court, and again very worrisome, of coordinate jurisdiction at the same level, and then you have orders made in that manner, and then one seeking to topple or change the effect of the earlier order as if it is an appeal, but it's not. That's the nature it takes. Now, ex parte in the sense that some person may not be given an opportunity, it's allowable in the rules of court anyway, not being given an opportunity to come before the court to explain his part of his story, and then by way of an application, ex parte made by an applicant, and then the court just listens to that one party, the applicant, and then sees the case as presented before that court. But it is required that it should have been in very special circumstances. And the very strong point that stands that would have justified that is urgency, and that without which something was going to go wrong and get bad. Then you give an order one way or the other before you get into the main matter. So in the context where, if I'm allowed to get into it, where the office or functions or performance of the functions of the office of the national chairman of a political party, the PDP, will really be affected by an order to be given in this manner. And then he is not, because the substantive motion, that is the motion put on notice, is not before the court yet for hearing and determination. So he is not required to be in court. But his fate, whether for 1 day or for 2 days, but by the rules 7 days, is going to be determined, and determined with substantial effects on him. That is the nature of ex parte application and interim order made pursuant to that ex parte application. And that is why the courts have always enjoined, superior courts enjoined lower courts to be very circumspect, to be very careful, and in rare cases even grant ex parte orders. So with what had happened, and you see one court starting in River State making an ex parte order to that extent, and we saw the effects of it and the magnitude of that effect, to the extent that it could make a person not to perform the functions of his office, more or less like you are asked to leave the office, more or less like you've been removed from office. Then the questions began to rise. Is there a procedure of removing this person from office, or even a procedure for handling grievance in terms of disciplinary procedure within the parties and all that? And because it's also one that is around the politics and political actions and all of that, you saw the reaction in Kebbi. And they were like, no, we can't have this person be removed, whether it's for 1 day or 2 days, in this manner. Then the other action came up. So that's why the judiciary is disturbed. And how have they drawn the judiciary into this debacle by politicians? Politicians could afford to do this within their political parties. It would have been an internal thing. Though not decent for democracy, but where now they have infiltrated the judiciary. And like I said, it's very important, because the judiciary should still be counted and seen as the last hope of the common man, as having integrity and as being independent. Then you're infiltrating the judiciary and then getting them to be ridiculed in the way that we see it today. And then you see the orders coming from south, then north, and south again. Who knows whether another will now probably get back to the north. It's disturbing. That's that situation.
We talk about the politicians using this context still, infiltrating the judiciary, but does the judiciary itself not bear any responsibility for this ridicule it has been thrown into?
It's something that is a mix. Let me say it's a mix, even when I sit and I explain this. Ordinarily, Section 6 of the Constitution of the Federal Republic of Nigeria 1999 as amended empowers every court as listed in that constitution, including the High Court, to entertain matters that have been brought before the court. So you could see that when the jurisdiction of the court has been activated by a process duly filed before the court and brought before the judge is under duty to look at it one way or the other. It is only a question of the integrity and the activism of the court that will further be expected that the court should look at this matter and direct one way or the other. That is why, outside of the substantive laws and the procedural laws that may define the powers of the court has its inherent jurisdiction that can be excised to address some of these issues. And how is this? You have a matter before you, and then you are allowed to look at it. And most cases it happens, especially even with ex parte application. The judge may ask you, no, I can't grant any of these orders in this ex parte application. Quickly put the other party on notice. And then probably even abridge the time that the other party was required by law to respond to this motion on notice, such that you can quickly get the other party to come. And then, because you have looked at the face of the prayers on the ex parte application, vis-a-vis the prayers on the motion on notice, the substantive. Because sometimes if you answer this order, this application that were made ex parte, answering one way or the other, you may be drifting into the questions that are asked in the substantive motion, the motion on notice, and answering it in that manner. Imagine like this now, by that order, somebody was out of office, and the functions of that person have been asked to cease. So the concern and the worry of the judiciary, and I think it's justified by the invitation now and the summon now, so that it's not just that we're just talking, is that if it goes this way, then of course it's seen clearly that the courts were not circumspect. The courts were dragged into these issues by politicians.
Talking about the circumspectness of the courts, you mentioned a while ago that in many of these instances, if not all of them, as very likely is the case with the PDP national chairmanship debacle, different parties are the ones who bring up these cases in courts. The guys who brought the matter in Rivers State are different from the ones who went to Kebbi State, and are different from the ones who went to Calabar as well. And you also identified a while ago that even maybe processes or facilities to be able to identify when these things are going on, even if they are brought in by different parties, may be a challenge for the courts as well. So are the courts limited in their ability to identify even when these instances are before them and act accordingly, or maybe it is that plus they're also in collusion with the politicians or the other actors?
Yes, they could be limited. That one of the reasons you could have conflicting judgments could be judgments given per curiam, that is out of ignorance. The ignorance could actually be about the existence of a matter of the same nature or on the same subject matter. An example could even be from the courts, the high courts that are numerous, where you have the state high courts and the federal high courts. And even the state high courts, you have all the states having. So it becomes narrower when you're going to the higher courts, the Court of Appeal, and of course the Supreme Court. The Supreme Court would have just meant that just one. But take the High Court, for instance, which is what we're discussing now. The Honorable Justice Bassam in Degema, as far as even in Port Harcourt, in River State, Degema is another stretch end of River State, and sits in Degema, for instance. And entertains, like I said, Section 6 of the Constitution allows him, gives him the power to entertain matters brought before him. The discretion is his as to how he sees it. If you're not satisfied, you go on appeal. Or if you're not going on appeal, approach him and explain why that order should be vacated. That opportunity was there. Now, this honorable judge sat there and considered in the interim an application made ex parte, pending the determination of the motion on notice, and made one order or the other. You may not be satisfied with the order made. The discussion going around now making topical issue is actually because of the nature of the matter and then the effect. Then someone sits in Kirby. If I'm not mistaken, that was a state out of Sokoto also, and far away, and just few days, 24th and probably 26th, and never perhaps. It's a matter of conjecture, so you assume. But in real terms, how was there a communication between River State Judiciary and then that of Kebbi to get the judge in Kebbi to know that this issue before the judge is same subject matter? Parties different, no doubt. In fact, parties even is a mix of it. The second defendant in the matter in River State is the same. In fact, the first and second defendants, same in the case in River State and same the case in Kebbi. Apart from the applicants themselves that are different. Now, you've got there in Kebbi, and you don't know whether this thing happened in River State. And then the Kebbi judge, the same Section 6 would allow that judge to look at the matters before the judge. And this an application. Was it properly brought? Has it been filed? Is it before the court? Does the court have the power, the jurisdiction to entertain this? If these answers are to the positive, then the court will look at it. But I think this is outside of just the substantive laws and procedures and all of that, but the context of saving the integrity of the judiciary and the effect of these kind of orders. And it is clear also in all the rules that ex parte orders should be given sparingly. And this is the reason. This is the reason.
All right, we'll go on a break right now. Headlines 5:30. When we return, we'll look at the CJN summons and what exactly the CJN might be hoping to accomplish and what could be accomplished by the CJN summons. Deeply stating, hard fact return shortly.
Let's talk. Keeping up with political issues and developments around you only on Nigeria Info.
Headline News, Nigeria Info on
92.3.
Headline News.
Welcome, here are the headlines. Agoni stakeholders frown at Siemens' low pace of work as trailer falls off a later bridge 1 month after protest on poor state of Ekine on Nair Road. Igboeche youths reschedule protest against the bad state of Igboeche-Ekine Junction Road. A weekly sit-at-home in southeast cities generates concern. University students dread ASU strike. Open grazing bill into law. President Nigeria bans payment monopoly of Apple Google. In business, CBN directs banks to publish names of forex policy defaulters. And those are the headlines. Details at 6. Contact our newsroom on 0818 90017. For more stories, visit www.nigeriainfo.fm. Thanks for listening. I'm Dayo Dee-Shark. Good evening.
What we do goes beyond bringing you the news. We give you a chance to talk about it. Your opinion, your voice.
This is 92.3 Nigeria Info, Port Harcourt.
Your number one news, talk, and sports radio station.
And now, Hard Facts.
Hard Facts with Dayo.
Welcome back. 27 minutes to go before 6 p.m. It is Hard Fact. I'm Dayo, and we're live on Nigeria Info. Conflicting court orders. CJN summons 6 chief judges. NBA Laments. Courtesy Premium Times. My guest once again, Henry Ekine, is a lawyer and with the Committee for the Defense of Human Rights. Henry, welcome once again.
Thank you.
Now, to the summons itself. What do you suppose the CJN wants to accomplish or will accomplish with this? Is it going to sanction this chief justices that is invited? Is it going to sanction the judges? Have they erred? You know, can we even exactly say that the judges who are granted these orders have erred? Is there the consequences they're going to be facing as a result of that? Please address this.
On the face of the order, or of course all the orders, on the faces of the orders that I've come across, not see apparently very clearly a situation of erring, whether in law or otherwise. That's how can that be examined? Are these issues outside of the powers of the courts that entertain them? 2, are they limited in any way to make such orders? Apparently no. 3, especially those that came subsequently, not the first. The first may very easily be exonerated in the sense that there was no order in any way before the Rivers State High Court made its order. So you may raise questions against the subsequent orders because that they ought perhaps to avert their minds to the existing preceding order. But like you asked, very straight, on the face of it, I doubt, speaking clearly, to the best of my knowledge, what would have been the error if they are to be considered to have erred? Erred in law in what regard? Have they disobeyed any extant law, or have they acted outside of their powers? These are the areas.
How about the issue of sparingly issuing these ex parte orders, especially in this particular context?
That's now the aspect. So asking whether they have erred, that you would have anchored that fault on a premise that is erred, or that the matter was so. Haven't addressed that.
No,
Given these orders,
the CJN summons now.
Yes, giving these orders in the manner they are flying, and outside of the caution, will attract the attention of the CJN. Don't forget, the CJN is the chair of the National Judicial Council that has the power constitutionally created under Section 153 of the Constitution of the Federal Republic of Nigeria to question the conduct of judges and judicial officers, to discipline them, and of course to inquire into their behaviors. Now, there have been numerous situations and cases and occasions that the courts have cautioned the use of ex parte application to grant ex parte orders. And the reason for this could be where the judges may be questioned. The reason for ex parte application is clear. It should be for special circumstances considering the urgency of certain matters. Now, you may be asked the question, assuming they are put on the hot seat now, what is the urgency that you perceive on the face of the application before you, that you never restrained yourself at all, and you speedily granted to this massive extent, and knowing the implication of this order? That can be a question that could be put on any of my lords. Another possibility could be, especially for those that this came before you, but their excuse may be, how would I have known? This came before you, and then you didn't avert your mind to the subject matter having been entertained by your brother judge, and then the order that your brother judge has given that is subsisting. And again, the nature of your own order, such that, especially the one that came very clear, as if you're restraining, staying an order made by your brother judge of the same level of court, it is strange. You do not have that power. You can't sit on appeal or in any way to review the decision or order made by your brother judge of the same level of court. Those could be issues that may confront them, because it means that if you're making reference to it, one of the orders was clear to that effect. If you're making reference to a preceding order to the extent that it should be stayed, meaning you are already exposing yourself that you are aware of the existence of that order.
So, summoning the CJs by the CJ now, are they simply going to have a conversation the likes of which we're having right now in the studio?
No, I don't think so.
Say, that guy shouldn't have done that. Why did he do that?
I don't think so.
So what's the essence? What's going to happen?
Dayo, do you know that even the summon alone, right, is an indictment? But I think that beyond, because what I read coming from the instrument that communicated the summon out to the public, beyond seeing the CJN, that they are going to further meet the National Judicial Council. The National Judicial Council is not convoked at any time for fun. It's not a tea party. Before you are being summoned, and the council will be constituted to hear you, meaning that there's an infraction or there is something that needs to be addressed by way of caution. This may come up not quite in the way of discipline as suspending a judge or expelling a judge, but could be a reprimand. Now, certainly, before the summon, in my view, that there has been a perceived infraction. Now, like every other procedure of discipline, there are different levels of sanction. It could be a warning, it could be a reprimand, it could be a suspension, it could be an expulsion, which in this case could be a sack. But it might not get to any of all of these. But you know what? Even if it is just a reprimand, it means that you may have been found, whatever degree, wanting in some way, and then some word of caution. So there could be warning, there could be a restraint. And this restraint, I had said earlier, has been there before to all judges, that do not use this instrument the way it's been seen used now, and use them almost exclusively in certain circumstances. You and I would begin to ask the question even before the NJC will convoke its committee, and then to look at that. Where is really this urgency in such a way that if we do not say, hey, Mr. Chairman, step aside, something was going to get bad? Or where is, there are numerous situations where it's been justified. Or where is the urgency that if this man were to act in his position in 1 or 2, 3 days, is he going to likely package the party and put in a bag and take it to probably Dubai or in Hong Kong? Or now that the Taliban are there, that people are running away, is it to Afghanistan? So I don't see that urgency. with respect to the use of ex parte application. Those are probably the concerns. And then again, with the concern that the judiciary is now seen in the eyes of Nigerians as playing the political game and being used. So perhaps the CJN is going to also end up using these 6 judges to say, look, let us be seen to be firm in maintaining our integrity and independence, and so that Nigerians will have hope and confidence in us in such a way that they would not perceive that the politicians can very easily infiltrate us.
Via Facebook, Oka Abenchi goes, the NJC is coming late. The kind of injunction judges in Rivers State do grant is shameful, to say the least. There are some notorious judges for that. They're drafted to issue controversial injunctions. The NJC sledgehammer should fall on them heavily, so as to serve as warnings to other judges. And via WhatsApp, Goodwin, should the lawyers who filed these applications before the courts be said to be free from this show of shame? These lawyers know what they were doing, were taking advantage of the ignorance in quotes of the court and the judges. Very quickly, how about these lawyers also, who are the ones who file all of these applications for ex parte orders and interlocutory, this and that?
The same way. The entire corpus of the judicial system, of course, includes the bench and the bar, the judges, and then lawyers. Lawyers have repeatedly been reprimanded on some kind of matters we bring before the court. It begins with even the court that's entertaining your matter. Sometimes the court entertaining your matter will actually even reprimand you for bringing very frivolous, vexatious applications or matters, and the doctorate will not be of any merit. Now, the same way, the Judicial Council has also had causes to reprimand lawyers for bringing. So, in the context of this particular matter now, depending on how the judges will return, the chief judges, will return from the NJC. If they return with straight faces, I think some persons will be cautioned. If they return smiling, well, we wonder where the judiciary will be headed. But very well raised by that listener. The lawyers and the manner, with respect to all my colleagues, and particularly those who are even much senior, we are ministers in the temple of justice, and then we're also required, candidly, even by training and by the rules of our practice, of our profession, to even candidly advise your client. So it's not everything that your client brings to you. But like someone said, there are judges and there are lawyers that are probably are perceived, may not be justified, perceived in some way. There are lawyers that perhaps you even would say that, oh, they file very controversial. And they take delight in it. That if you hear the controversial issues, political issues in a space, maybe even in the state, and perhaps very soon, and very boldly I can say that, maybe in Rivers State we'll begin to identify that there are certain lawyers, and when it comes to the very controversial political issues, that you hear their name in any party, whether it's in party A, party B, party C, they are there. Oh yes, you have the right to receive any brief, any instruction. Of course, you're not limited to taking instruction from any political party alone. But why should these matters always be you?
Well, what's up? Good evening, Di. Your guest has said it all. I hope NJC will sanction all the judges involved in this case to serve as a deterrent to others. HM from about sent that. And on that note, I think that's a good place to wrap up the conversation. Thanks for joining in. Especially my guest, Henry Ekine, is a lawyer as well. He's also with the Committee for the Defense of Human Rights. Henry, it's, as always, great to have you here.
Thank you very much. Always a pleasure to be here.
Got a commercial break coming up. Major news at 6 p.m. If you've missed out on contributing to any matter on the show today, I'll take your thoughts after the major news at 6 p.m. on the open decision segment till about 7. Do please stay with us.